one of the issues that people worry about in the law of contracts is exactly what kinds of agreements do they cover. The basic definition of a contract is any agreement between two or more parties in which people either agree to perform or abstain from any act. Generally speaking, we talk about the ability to have gains from trade, and in the simplest kind of case, it means that I give you my horse and you give me your cow, a contract of barter. But in many cases, it turns out that the key element is going to be gains from trade over time, so that I'm going to lend you money today and you're going to repay me tomorrow. It turns out that we always use self-help devices in order to firm up these relationships. I may take security before I make you a loan. I may only make loans to people whom I trust. I may only make loans if somebody else is prepared to guarantee them. But in the end, these informal devices will come up short unless there's the security and the knowledge that you can sue somebody in the event that a breach takes place. There is no formal requirement in the law of contracts as such which says that agreements must be in writing in all cases. Indeed, thousands of contracts that people enter into every day have no written evidence whatsoever. You buy a newspaper, you pay $1 and you get the paper. It's a contract, there's an offer, there's an acceptance, and there's performance. But as contracts deal with a more complex subject matter, as the duration of their performance starts to increase, as the value of the contracting stuff starts to increase, writing is almost always required. And the reason is you cannot negotiate the purchase of a house with the same speed and rapidity that you can negotiate the purchase of a paper. And so what you do is you get lots of formal stuff, and the way in which it works, roughly speaking, as follows. You have a period of oral give and take in negotiation in which neither side is bound, even if they have quote-unquote reached an agreement. And then what you do is you sign a written agreement by both parties indicating the major obligations to be discharged. That's called the statute of frauds requirement. At that particular point, the property is not conveyed, because after you make the agreement, then you run inspections, first on the title papers and then on the condition of the premises, and only after those things are satisfied do you actually have the conveyance. If one wants to think about why contracts are so important, it turns out that contracts allow you to make improvements on public space when the government enters into various kinds of agreements with various contractors to pave the roads or to repair them. If you look at the private space, generally speaking, no individual can build all the things that are necessary, and the law of contracts allows you to specialize and essentially to take people with different sets of skills and to combine them in optimal fashion.